Much appreciated. And sorry, Mr. Potter, I'll get you to mute your. Thank you. So yes, good afternoon, everyone. If you're new to the inquiry or watching this back, my name's Alistair Edwards. I'm a reporter with the Planning and Environmental Appeals Division, tasked with looking at this particular wind farm application. Everyone should now be well versed in proceedings and the arrangements, but for the purposes of this hearing session, I'll just ask the parties to introduce themselves, starting with the applicant, Mr. Hardy.
Thank you very much. So David Hardy, partner with CMS. So in this session, I've got Mr. Campbell, so Keith Campbell, who is going to be sharing the talking role with myself. We also have Mr. Mackay. He's probably the new face on here. So James Mackay, he is from TNEI listing, and principally, if there's anything in relation to noise, then he will be dealing with that. And we've got Mr. Potter from the client as before.
Thank you. And for the council, Mr. O'Carroll.
Maurice O'Carroll, advocate barrister representing Argyll Bute Council. I'm accompanied today by Ian Kelly, independent planning consultant, and Shelley Gould, planning officer for the Argyll Bute Council.
Thank you. Now, before we proceed into the agenda, I think there's two outstanding procedural matters. So we'll take the first one because it's quite simple. An updated statement of agreed matters and policy was going to be provided over lunch. Has that been finalised?
Still in the process of doing that, so it won't take long and it will be available, but we haven't actually got that finished.
Okay, well, once that is, we'll get it uploaded and we'll update the core document list. Thank you. Now, the second point was, as we left it, there was an outstanding matter from the policy hearing session to do with the council's response to the additional environmental information. Just let Mr. O'Carroll come back. Yes. So I've had to think of this over lunch and I've had to look at the regulations. I think possibly we've been conflating a couple of the further processes here. So my understanding is that the council, the planning authority, plus any statutory consultees have until the 3rd of February to respond to the additional environmental information. And that's not a two-stage process. It's not that we have to wait for the statutory consultees before the planning authority can make a response. It's the same date for all parties. But subsequent to that, I'd also agreed that the further written submissions on ecology, that I would allow the council a further period of time to comment on that further written submission. And I think that is at the point that the council could make their submission in terms of ecology and on the biodiversity enhancement if they needed to without having to go to their committee. And then beyond that, we've got the further written submissions on the Cross Dykes wind farm aviation lighting. So as I see it, I'm not sure there's actually an issue, Mr. O'Carroll. I think if the council wants to make a response on their own back, they could do that by the 3rd of February. But then they have the further written submission period for the ecology where they could discuss any matters without having to go to the committee.
Thank you very much, sir. All understood.
Great, and you agree with that? You're happy with that process?
I am, thank you.
Thank you. Okay. Great. I'll put all that into a further written submission procedure notice, which will go out, as I hope, on Monday. And then parties will see those 3 processes written out with the new timescales for those and closing submissions. So without further ado, we'll move on to the agenda. We've introduced everybody. We already discussed on day 1 about the progress of the agreed statement of conditions. And other than the redrafting of condition 14, which I have before me, and I hope you do as well, I think it was the 13th of January is the most up-to-date position we have on conditions. Is that correct? Yes. Okay. So we'll move through the agenda fairly simply. So item 3, conditions to be attached to the section 36 consent. Could you just clarify with parties, are you content that there's no condition regarding duration of consent? Mr. Hardy.
Mr. Campbell will probably do. I think if we go to him first, and then if there's anything I need to pick up, that will be the best way of dealing with it. You're on mute, Keith.
Indeed, apologies. Yes, the applicant's content that providing the duration is stated in the determination section of the Minister's decision letter. That suffices, and that does seem to be the approach that has been followed by ministers in recent decisions.
So, Carol, I'm not sure, do I come to you in the first instance or do I go to Miss Scholl?
I'd defer to Ms. Gould, and then
Yes.
I'll chime in if necessary.
Okay, are you content, Miss Scholl?
I'm content, yes.
Okay, so I'm looking at the conditions as we're going through here, so I'm just scrolling down. There's two conditions here on radar mitigation and aviation radar. They're under the section 36 conditions. Can I ask why and why those are there and they're not planning conditions? Is there a particular reason in this case? Mr. Campbell first.
I think that again is fairly consistent with other section 36 consents and indeed the conditions as proposed by NATS and Glasgow Prestwick in this case. I think that probably reflects that these are essentially technical conditions to mitigate potential impacts on national airspace or DPA operations and ensure wider aviation safety and not directly at least related to impacts on the local authority area. So probably a combination of that technical aspect and the wider, more national focus of those conditions.
Ms. Gould, is the planning authority happy for those to be defaulted to the section 36?
Yes, we don't have any issue with that.
Do parties have any comments on the other four conditions to be attached to the section 36 consent? Mr. Campbell?
No further comments from the applicant, sir.
Okay, Ms. Gould?
No further comments from the council.
Okay, so if we scroll down now, we're going to look at item 4, which is conditions to be attached to the deemed planning permission. So I'm just going to jump to those that I have questions about, but if there are others, we can circle back to those after. So based on condition 8, in terms of controlling the heights, particularly turbines 7 and 9, is there now agreement on that approach? I'll go to yourself, Ms. Gould, first.
Thank you. Yes, I think we do have agreement on that. My only question was whether there should be a bit more of a cross-reference between the final appearance of operation of turbines in condition 8 and then the specific condition which refers to turbines 7 and 9, which is condition 16.
Don't
Campbell?
I don't think I think the applicant would be happy to that. I mean, can I suggest that just as simple as in relation to condition 8 part 2, we could simply add something along the lines of subject to the terms of condition 16 in relation to turbine 7 and 9, comma, and then the remainder of that part, which would provide a link between the two conditions.
Ms. Gould, will you be happy with that approach, subject to the terms of condition 16 in relation to T7 and T9?
Yes, that would be appropriate.
Now, on condition 10, that talks about battery energy storage systems. Is it appropriate for us to put a suspensive condition there and delay the design and the layout of those particular items until a later date. On that, I have noticed that the description of development provided by the applicant now includes a line restricting it to 5 megawatts, and also saying that it will be contained within the, I think it's the construction compound area on figure 3.1, which is the site layout. Is that now sufficient detail to control that element of the development? Ms. Gold first.
Yes, I don't think the council has any issue with reviewing the details of the BESS at a later date. In terms of the generation of 5 megawatts, I think we would prefer that was fixed, because that's the scheme that we reviewed and took to our planning committee. So that's the only point we'd like to make on that.
Okay, and sorry, so do you think the description of development as revised, well, provided by the applicant, that's sufficient now? I think, let's pull it up. I don't know if you have a copy of that. If not, I'll share my screen with you.
Yes, if you could just share, it's probably quicker.
So this is Annex 1, which would be as part of the conditions. And you can see here, I think it's this bullet point there, yes, an energy storage compound to store batteries with a 5 megawatt capacity, which would be within the construction compound footprint. Is that sufficiently detailed enough to satisfy the council?
It is, yes.
Super, thank you. Mr. Campbell, do you have any comments about the condition on BESS?
No particular comments, sir. I mean, obviously happy to hear what Ms. Gould says. The condition itself obviously requires further approval in terms of appearance, lighting, fencing, and so on. So we would certainly agree with the council on that. As regards the 5 megawatts, I think the applicant's position is that that was specified in the application, so it is contained to accept reference to 5 megawatts.
Sorry, too many tabs open here. So if we scroll down now to condition 12 on redundant turbines, there's a second part to that, which is the condition won't apply if there's any outages or operational constraints which are outside the company's control. Now, when I was reviewing the Clachay Glen decision from ministers, that particular section or part was removed from the decision. So is this part necessary in this case, Mr. Campbell?
The applicant would submit that it is necessary. It is essentially an exception to the general requirement in Part 1 and reflects a situation where it is not, it is beyond the control of the applicant that the turbine has not generated for a significant period. So in those circumstances, it suggests that it is reasonable that the obligation to submit the decommissioning plan would not apply.
Ms. Gold, any observations on that?
I would say it's not necessarily a huge concern for the council, but I would like the condition to be consistent with those that have been approved on other recent schemes. So if this is a sort of a new or additional measure which doesn't have any particular specific relevance to this application, then I don't see the reason why it should be included.
Okay, thank you. I've taken note of both your points, unless Mr. Campbell, you have something else to say.
Just say, I think it is something that has, I mean, I think there was reference to Breackerie Glen there. I mean, there have certainly been consents in the past where that element has been included. So I think it has been a mixed bag, and it's not the situation that it has never been included in a section 30 in a consent.
Yeah, just add to that, sir. If you point yourself towards the Rowan wind farm consent, which is CD 014008, condition 18, which is a different format, a different style of wording, but it essentially says the same thing, and that was agreed with the council and the ECU earlier this year. Thank you.
Thank you, Mr. Potter. Okay, if we move on to condition 14 on aviation lighting, obviously we have a revised version of that. You all have that before you? Yes. Okay. Now, are there any comments in terms of the wording of this condition as written? I think there was some disagreement to do with the review periods. Mr. Campbell.
In terms of the review periods, the applicant's position is that that is a reasonable and proportionate requiring review at those intervals. And there is obviously a process that has to be followed and undertaken, reports and so on. And these have been accepted in the as reasonable periods imposed in other consents, and I think also reflected in the recent Nature Scott aviation lighting guidance. So I think the applicant's position is they are reasonable, proportionate, and indeed consistent with other decisions that have been issued by the ministers.
Okay, Ms. Gold, I think your comment here is to do with the review periods being too long. Would you like to add to that?
I understand that this is a sort of standard condition with accepted wording. The concern that we had from the council's perspective is that given the importance of the dark skies, particularly in the Mulligan Tyre, that a particular set of circumstances could arise in which we would end up with up to a 10-year period where the aviation lighting was not being sufficiently mitigated. That instance, correct me if I've misunderstood the writing of the condition, but that instance could be that the reduction of the visible lights through the ADSL proposals, it's reviewed a year, 3 years, 5 years. If at neither of those points it's deemed possible to install that system, the subsequent review would be another 5 years. So if we were looking at a 40-year permission, then potentially a quarter of that permission's life could be without a mitigation on the aviation lighting. But that's the point the council is making.
In that circumstance, I would have thought that if it hadn't been, if at the 1 year and 3 year and 5 year, those reviews had concluded that it was not reasonably practicable to install ADLS, that is the point of those reviews. So there would be a reason for that 10-year period.
Yeah, I mean, my understanding here is we've got a revised condition now that includes the mitigation to the lighting that we've discussed over the last couple of days, including if there's mitigation failure. This part of the condition is to do with technology that's, as I understand it, not currently available, and this would allow a review for when that technology was available and whether or not it was reasonable to apply it to this particular wind farm. Is that correct? Yeah,
Yes, that's correct. The condition deals with both the aviation lighting system as proposed in the report and the potential for ADLS to come forward in the future.
Right. So does that change your stance, Ms. Gold, at all?
It doesn't provide any certainty in a situation which is a sort of hypothetical future, anyway. So I don't feel that it provides any more reassurance on any certainty that the mitigation could come forward. It's just a 5-year period after the first 5 years. Perhaps it just needs some sort of caveat in there, that condition, which might refer to, or equivalent system, or, something that may come online in place of the ADLS.
I wonder if the terms here, so it says after it says every 5-year anniversary thereafter, comma, and unless otherwise agreed with the planning authority. So there might be an opportunity there to discuss a review date and earlier. So if a new technology came out, the council could raise that with the developer at the time or operator. Would that satisfy you, Ms. Gould?
Yes, that would be satisfactory.
Any other comments in terms of the aviation condition? Mr. Campbell?
No further comments, sir. You'll have seen the revisions that were proposed in relation to the matters that were discussed during the landscape session, and which you summarised at the end of yesterday's session.
Okay, so moving on to micrositing, condition 15. I just ask the council why these limits don't afford the planning authority sufficient control beyond 50 metres.
I think on rereading the conditions, I think actually they do provide the flexibility, and they do allow us to have some degree of control within the specified up to 50 and over 50 metres. So I think we are happy with the condition as it is.
Any comment on that, Mr. Campbell, before we move on?
No comment, sir.
Okay, move on to condition 16, which we've previously discussed briefly. Is there any ongoing disagreement concerning this condition to do with the micrositing or reduction in height of these turbines? Ms. Gold?
No, we're content with that condition.
Mr. Campbell, any comment?
Nothing to add, sir.
Okay, we'll move on to condition 22 then. Now, this is just a question from myself to yourself, Mr. Campbell. What happens if the habitat management plan isn't regarded as a success?
That is covered in part 3 of the plan. We would suggest, sir, and this is based on Nature Scott's proposed revision to the condition, which is accepted by the applicant, and provides that management measures can be devised to ensure that HMP objectives are achieved. So we would suggest that there is provision. Obviously, a detailed habitat management plan will have to be prepared, and it will have to include vision for reviewing the success of the objectives, and should they be found not to be fully successful, to revise management measures where necessary to ensure that those objectives are achieved. So that mechanism must and will be built into the detailed habitat management plan.
Thank you, Mr. Campbell. And Ms. Gould, are you content with that approach?
Yes, I am. Nature Scott are likely to provide further comments on the outline habitat management plan when they provide their written submission. So, of course, those comments would need to be also taken into account.
In terms of condition 26, I don't think this is an issue between the parties here. More RSPB Scotland have raised more detailed wording, but are you both content with the condition on planning monitoring officer? Ms. Gould?
Yes, I don't have any issues with that condition.
Now, I noted on the Clackey Glen decision, not the report, the decision, that the compensatory planting was moved from the planning conditions to the Section 36 conditions. Is that an approach that I should promote in this case? Mr. Campbell?
It was, and that seemed to be a fairly recent shift in approach. Ordinarily, or certainly up until recently, they seem to have been imposed in the deemed planning permission rather than the Section 36 consent. That said, the applicant has no objection should you wish to impose that in the Section 36 consent.
Ms. Gould, do you have any comments on that?
We wouldn't have any issue with that condition being moved to the first section of the conditions. That would be fine.
Okay. I mean, I think basically it will come down to enforcement of that condition, moving away from the planning authority into the remit of the Scottish ministers. Is that correct?
Yes. Yeah.
Okay. And in terms of the hectareage, we briefly noted that earlier. Are parties content now with the 52.93 hectares? Yes.
Just content with that, yes.
And the council is content too.
Yeah. Mr. Mackay, I think we're coming to yourself now. In terms of the noise control, the council is asking for amplitude modulation effects to be included within condition 40 and operational noise. Why would that be the case here? What do the council mean when it refers to separation distances and headroom? So I come to yourself, Ms. Gould, first, and then possibly the specialist for the applicant can come in.
Obviously, I'm not a technical noise specialist, but I have consulted our noise consultant extensively on this matter and on these conditions. With me. So, in terms of separation distances, my understanding is that's just the receptors. So it may be that in the Clackey Glen permission, and I haven't double checked the distances, but perhaps there is a greater distance than there is for this planning application. In terms of the AM condition, the issue that the council is quite strong in wanting to apply that to this permission is that because that condition, it would place the investigation burden on the developer under complaint investigation rather than the local authority under nuisance provisions. We have a proliferation of wind farms. We do not have in-house technical expertise to deal with this matter, and so it would fail to provide the adequate protection. And our position is that the statutory nuisance regime is not a backup to matters that should be appropriately dealt with through planning controls in the first instance. In terms of headroom, my understanding is that it refers to the gap between the predicted turbine noise and the noise limit, and that developers, when they are showing their schemes, will only show all their cumulative schemes, they'll show them with no penalties applied, as these are only applied retrospectively once they're operational. So if that gap is less than 5 decibels, either the tonal or the AM penalty could lead to a breach of condition. Conversely, if the gap is more than 5 decibels, the developer could accept any penalty and remain within their noise limits. So they could effectively be allowed to continue operating without addressing the tonal problem or the AM problem, as they can still operate within their noise limit. So it's relating to the sort of mechanics of how the penalty scheme works. But the general principle that we're trying to ensure is applied to this application through this condition is that wind farms should operate without causing complaints due to tones or excessive amplitude modulation, and that's sort of the balance that the local authority is trying to achieve here.
Thank you, Ms. Gold. Now, taking that all on board and written it out here, one thing that just comes to mind here is that when you have two regulatory processes, generally speaking, we're told not to use a condition where there is a separate regulatory process. So it seems to me this seems to be a financial issue, or maybe it's an employment issue. But could you talk more about that in terms of covering 2 regulatory processes?
The council would have a statutory requirement to investigate any noise provisions. So I'm not disputing that. What we're saying is that our position as a council is that in the first instance, the planning controls should be reducing the need for those enforcement measures.
Thank you. Now, I'm not sure if I go to yourself, Ms. Campbell, Mr. Campbell, sorry, if I go to yourself, Mr. Mackay, but I'll let either of you come in now.
I'm happy to pass
Mr.
over
Mackay.
to Mr. Mackay.
Thank you. Good afternoon, sir. So, I mean, my comments on this really, going back to the question you posed, is, is there any reason why the provisions would not be sufficient? In my view, they are sufficient, and the use of statutory nuisance in the event that AM were to occur on site is appropriate. In relation to the investigation of complaints, I would note that draft condition 40 put forward by the applicant does place the onus of any initial noise investigation on the operator, and it's a very detailed condition which has been applied on a lot of wind farm sites, which includes noise levels and tones should they be present. Specifically in the relation to the inclusion of a condition relating to AM, I'd probably point back to the information included in the environmental statement and in core document 0540, which was the technical appendix in relation to noise. Amplitude modulation was discussed, and specifically under paragraph 3.3.10 in that document, which is on page 20. There's a quote from the IOA GPG, the Institute of Acoustics Good Practice Guide, which notes that the evidence in relation to excess or other amplitude modulation is still developing at the time of writing. Current practice is not to assign a planning condition to deal with AM, and that is still the relevant good practice guidance. And in my opinion, in the event that AM were to occur, it would be appropriate to deal with it under statutory nuisance. I don't think a condition is necessary, because it's covered by nuisance should it occur. In relation to the points, about headroom, I'm not quite sure how that compares between the two sites. I mean, I wasn't directly involved in Clackhead Glen, although based on the comparisons I've done, I see no significant differences between the sites in terms of setbacks between the nearest turbines and the nearest dwellings. Predicted levels are broadly similar and background levels are broadly similar. So, I see no reason to make a distinction between the two sites either.
Thank you, Mr. Mackay. I didn't actually ask him the question about comparison to Clackhead Glen, but I can appreciate why parties are raising that to my attention. Ms. Gold, would you like to come back at all on anything that you've heard?
I would just reiterate that the technical noise advice that the council has received is that AM is required in this instance to mitigate the noise impacts of the proposed development on this location, and that my report of handling and my recommendation to committee members did also include reference to noise conditions required, including AM.
Okay, I think that's a matter I'll have to take under consideration myself. Anything else on that before we move forward? Now, we've already talked a wee bit about this, but is everybody content with the definitions that are in table 1 of the conditions?
Yes, from the applicant.
Okay, and from the council?
Yes.
Yeah, and that of course includes the new description of development that we've got from the applicant.
Yes.
Are there any other conditions that parties would like to comment on? Mr. Campbell?
Nothing from us, sir.
No. Ms. Gold?
No further points from us.
Okay. Mr. O'Carroll, you've sat up there. Was there something you were going to say?
There isn't, I was just checking.
Right. Well, in that case, moving on to item 5, just to confirm with parties, there's no need for a legal agreement or obligation in this case. Is that correct?
Yes. No Section 75 agreement. There is provision for an agreement under Section 96 of the Road Scotland Act, and that is incorporated in one of the proposed road conditions.
Condition 36C.
Condition, yeah.
Yeah, so it's a suspensive condition that really requires that, or if needed. But yes, that's perfect. Now, are there any other relevant matters that anybody would like to bring to my attention? No?
Nothing further from us, sir.
Well, all that remains for me to say is thank you to everybody for your participation this week through the inquiry. We've agreed dates for summaries of case, revised ones, and I will issue a fresh procedure notice next week, giving the dates for the other processes. If there are no other matters, I just let's
There's just the one matter, and that is the revised wording. It's not going to take very long, but the revised wording for the statement of common grounds. If we're trying to agree with that with the council today, would you be content if we put that in tomorrow?
Yes, that would be absolutely fine. Thank you.
So we'll sort that out with the council and submit it.
Thank you. Much appreciated. With an updated core document list, if you don't mind.
Yes.
Thank you. Okay, well, thank you all for your presence and safe journey home. Thank you.
Thank you very much indeed, sir. Thank you very much.
Bye-bye. For the time. Thank you.
Thank you.